today with us, we have a seasoned legal expert in this field. And I believe that when he comes up to share his experience, his wealth of experience with us, that it's going to be an impactful one for us and we'll have a lot to take home. Yeah, so on this note, I think let me call on the chairman of the committee, that's in the chairman of the Medical and Health Committee of the MBA Garki branch, in person of Mr. Ebenezer Iguatu, for his opening remark. Mr. Ebenezer.
Can you hear me? Can you hear me? Can you hear me, please?
Yes.
Hello? Okay. Good afternoon, esteemed participants. Thank you very much. On behalf of the Medical and Health Law Committee, I want to sincerely welcome all of us to today's webinar, where we'll be discussing a very topical issue: strengthening health policies in Nigeria, the role of lawyers. A good number of our colleagues do not know that they have any role whatsoever to play in shaping policies. And where they do not play that role, a gap is created. And what that means is that the outcome of the policy will not be what we will all be proud of at the end of the day. It is not that the other people who are not lawyers are doing something wrong. No. It is just that the legal components and the professionalism that is required to make that document what it ought to be will be lacking. I will give an instant example. In 2023, 15th of September, 14, 15 September 2023, I had the privilege of contributing on a committee that produced a policy. And that policy was launched last year, 2024 September. The policy is Federal Ministry of Healthcare, National Patient Safety and Care Quality Policy and Strategy Implementation 2024. Out of over 30 persons that worked on that document, I happened to be the only lawyer. Now imagine where there was none. So the essence of today's webinar is to empower you so that you can also build a career path in addition to your litigation, corporate practice, and other areas of practice. And as our regular participants already know, the Medical and Health Law Committee of MBA Abuja hosts a webinar monthly. So this is our August edition, and by September, we'll be discussing another topical issue, which is understanding patients' rights and medical. We want to welcome you. This webinar is accredited by ICLE. It has 1 CPD points. At the right time, attendance form will be shared. Please endeavor to fill the attendance form and submit so that you can earn your points. You already know that if you fail to do that, you will miss out. Secondly, the webinar is also being streamed live on our branch, MBA Garki branch YouTube platform. So I can see that the Zoom link is already filled up to capacity. So tell your friends they should just go to MBA Garki branch channel on YouTube, just the name MBA Garki branch on YouTube, and they will be admitted and join the webinar. They will also get their CPD points. Thank you very much, and we wish you a wonderful webinar time. Thank you.
Okay, thank you very much. That's the chairman of the Medical and Health Law Committee of the MBA Garki branch. Yes, like you rightly pointed out, please, you can talk to you can intimate your colleagues and other participants that are finding it difficult to join us here on Zoom. They should go to our YouTube channel, that's the MBA Garki branch. YouTube channel, and then they joined there. Thank you very much. So at this point in time now, I would like to yield the mic to the branch chairman of the MBA Garki branch for his welcome address. Mr. Chairman, are you with us, sir? Please. I yield the mic to you, sir.
Hello, can you hear me? Can you hear me?
Yes, we can, Mr. Chairman. Good afternoon.
Good afternoon, sir. Good afternoon, distinguished branch members. Good afternoon to everyone. I want to welcome every one of you, members of the branch and non-members alike, colleagues and non-colleagues alike, to this webinar this afternoon. I also want to very specially welcome our guest lecturer for today, who, by the grace of God, happens to be my senior at the university. We most respectfully welcome you, sir. I want to welcome everyone to this webinar and encourage us to be very active participants in this webinar. This webinar is part of the series that steps the branch has taken to ensure that we continue, like the chairman of the Medical and Health Law Committee has said, we continue to educate our members on relevant topics concerning medical and health law and issues that they should know and they should be aware of and they should be involved in. And like it's also been stated, one of our greatest hallmarks and achievements in this administration has been to ensure that we are an ICLE meeting or a webinar. It will be covered by the ICLE and we'll get our ICLE points from there. And this is not an exception. So I want to encourage us to be part of it and learn the much that we can from this webinar. Thank you very much and enjoy the lecture. Thank you.
Okay, thank you very much, Mr. Chairman. That's Mr. Anthony Bamidele Ojo, the chairman of the MBA Garki branch. Thank you very much, sir. Okay, without wasting of time, we'll go straight into business. I believe our guest speaker is here with us already. He could hear us. That's the person of Udo Esquire. Yes. I'll be reading a short profile of our guest speaker so that we can have a little insight of who this person is, and as he comes to us to share with us his wealth of experience in this field of medical law. Thank you. Mr. Udo is a seasoned public health legal and policy expert with over 15 years of experience in proposing legislative and policy strategies to address critical governance priorities and enhance legal frameworks. He currently manages Resolve to Save Lives PE legal program in Nigeria, where he plays a key role in supporting the implementation of grants and projects to strengthen public health legal frameworks in Nigeria. His work extends to providing essential legal guidance on legislative instruments to ensure compliance with international health regulations 2005 and other international standards. Mr. Has been instrumental in driving public health legal reforms in Nigeria, co-developing critical assessment tools and supporting the review and strengthening of instruments. He has also been at the forefront of legislative education, conducting workshops and training sessions for parliamentary committees and other stakeholders. His expertise has contributed to the successful legal framework, to the successful legal reform, in over 10 states in Nigeria, including the passage of significant laws such as the Kaduna Public Health Law 2023 and the Jigawa State Public Health Security Law. Mr. Mm's commitment to improving public health extends beyond legal reform, as he has actively supported the development of regulation and guidelines related to food safety and quality in Nigeria. In addition to his notable contributions to public health, Mr. MM has held various roles in different organizations, demonstrating his adaptability and strong work ethic. His career encompasses roles as an election operations specialist, research fellow, and public and programs officer, which he has consistently delivered impactful results. Mr. Odo's academic background is equally impressive, with a master's in international affairs and development from Ahmadu Bello University and a master's in law from the University of Abuja. He holds a Bachelor of Laws from the prestigious University of Abuja and a Bachelor of Law from the Nigerian Law School. Beyond his professional achievements, Mr. MM is a published author with several research publications to his name, contributing significantly to the academic and legal discourse in his field. Wow, so I think this has given us an insight of the person who we have here today as our guest speaker that has come to enlighten and to educate us on this topic. Mr. MM, good afternoon and you are welcome, sir. I would like to yield the mic to you so you can school us on the topic, sir. Thank you very much.
All right. Thank you very much. And I really pleased and happy to be here. And it gives me great pleasure to, as always, share my knowledge and experience with colleagues to try to, get more legal practitioners, both in the public and private sector, to, participate in health-related issues. I'm so happy to be here, and yeah, thank you so much for the opportunity. And yeah, we'll definitely go straight to the discussion for today. I don't know if the presentation has been, shared or.
Okay, sir. I don't know if it's possible. You are a co-host, sir. If you could share your slides from your end, sir. I don't know if it's possible.
Oh no, I don't think I can because of the nature of internet I have right now.
Okay, sir. Yeah, so we're working on that. Okay, it's up now on the screen.
Right,
Hello,
thank
sir.
you very much. Yes,
Yes,
I can see. You
yes,
can.
it's up there on the screen. Yes, thank you.
Yes. So yeah, thank you once again. And so the discussion today is on strengthening Nigeria's health policy framework and the role of the Nigerian lawyers to support this process. As stated earlier by me, still remains Memudo, senior legal advisor with Resolve to Save Lives. Next slide. Next slide, please. So the purpose of this presentation is very key for me and very key for everyone here because we need to highlight what are the key roles Nigerian lawyers can play or should play in shaping and strengthening health policies. For so long, we have not really been included in discussions, deliberations around development of key legal instruments, even from the highest level of legislation and to subsidiary instruments like regulations, guidelines, as well as even non-enforceable policy documents. So it's important that we try to explain what all this means and how we as lawyers can actively contribute to this process. And as such, it's important to examine what are the present challenges as to why lawyers are not part of the processes, and also to prove and also to point out areas of opportunities for in that respect. And as with every presentation, it's important that we propose practical strategies for deeper engagement. And this is because health policy framework is important to all of us, and we are affected one way or the other. One of the critical examples I used to give is issues as simple as consumption of salt. So let me just draw in the present work. We are supporting both NAFDAC and the Ministry of Health in terms of Nigeria consumption of salt in the country. And over the last 20 years, while other countries were, trying to reduce consumption of salt due to the negative health impacts to population, both male and female, and to the increase in cardiovascular diseases, particularly um, high blood pressure, hypertension, and the rest. So how do you support this if you do not, understand what are the issues and how best legal instruments can solve the problem? And if you, leave it just only to the regulators and the non-legal persons, sometimes language within the instruments might be ineffective and also might not be enforceable. And we'll get to some of those examples. And it's important that as lawyers, we guide government in terms of clarity, enforceability, as well as sustainability of health intervention, and trying to ensure that Nigerians' health systems align with our international obligations as well as best practices. And over the last 6 years, as a public health advocate, I've seen that we as lawyers are the most effective enablers of effective health systems. And it is legal instruments that really clarify roles, create duties, create rights, and also protect citizens. So if we have lawyers participating in drafting, crafting, and also deliberations around health policies, health regulations, and even health legislation, those legislations would be very, very legally sound and effective. And basically, as lawyers, I would, not really know the composition of the audience here, but I can, if maybe I'm wrong, but I'm sure most of the audience here are private legal practitioners, and clearly we we support lots of clients in terms of clients like as a consultants, clients with people seeking protection of their rights or requiring provisions for damages when their rights have been violated by public health authorities or generally any authority on health matters. So next slide. Hello? Okay. So what is the foundation for the health legal framework in Nigeria? At the moment, the Constitution is the supreme legal authority, and following that, acts of National Assembly, which is acts of Parliament, as well as state laws providing statutory backing, and then in the hierarchy we have the next level, which are the subsidiary regulations, guidelines, as well as ministerial directives that are being mandated under the various laws. And then finally, we have policies and strategy documents which are being issued by relevant public health authorities to guide implementation of the laws or regulations. And for the purposes of this discussion, just trying to keep it at the highest level, we have the key institution as the National Assembly from a legislative perspective, I mean the State House of Assembly. Then at the policy level, we have the Ministry of Health, which provides policy leadership in the country. Then, for example, we have various agencies which support technical and regulatory role. The example provided here is the Nigerian Center for Disease Control, and you all are aware that in 2020, the NCDC played a huge role in supporting the mitigation of the spread and transmission of the COVID-19 virus, and this was done through issuance of various guidelines and basically guidelines. If you could remember, there were guidelines around proper disposal of persons who have contacted COVID are treated. And then guidelines around
Mr. MM, are you with us, sir?
and vetting of legal documents or instruments. And then we have other ministry departments and agencies that are involved in health issues, but not really has the lead in health, but they have some component around health. For example, we have, let me say, Ministry of Environment, which are very important in terms of environmental sanitation, which all of us are aware of, and which all of us have, over the years and in various states, we have specific days where it's called Sanitation Day. And on those days, persons are not allowed. There's a restriction of movement, which is enforced by the government or the authorities. And there are sanctions for persons who fail to comply with it. And just to start, a lot of these agencies, ministries, develop these laws without, really looking at some of the practical legal implications, as well as providing adequate exceptions to critical situations or to genuine issues. So once those kind of issues are in the legislation, it's always sometimes difficult to go against it because of the provision of the Constitution, which makes public health one of the grounds for derogating constitutionally guaranteed fundamental human rights. So next slide, please. So it's always important to understand how the legal framework works in Nigeria. Unlike education, health is not included in the exclusive or concurrent list in the Constitution. So due to this omission, whether it was intentional or negligent, health is basically now a shared responsibility between the federal and the state. And the implication is that the states have a major role to play in health policies. And more than often, states are not really bound by national standards, except those national standards are tied to any issues around national exclusive or concurrent issues, but still have health implications, like the issues of quarantine, the issues of drugs and poison. They are health issues, but they are exclusively within the federal mandate, and that means those issues are not within the legislative competence of the states. And just also to mention, this is for the purposes of, a federal system like Nigeria, even though the Constitution made health a dual or a responsibility to the federal and state. Most often, federal laws and policies provide national standards, and a lot of states align with it. Where an example is the primary healthcare development system, which was started at the federal level through the Nigerian Primary Healthcare Development Agency, and states had to, establish their own respective state primary healthcare development center to coordinate with the national. Same also applied with issues around health insurance, with the federal having the National Health Insurance Scheme, which is now the National Health Insurance Act, and states also now have their various health insurance schemes to really, complement with the federal level. And it's always important that while we are, working with the federal government or even state government who wish to, move ahead and be very progressive with their laws and with their practices, whether public health or medical practices, is always important that reference should be made to what is the federal practice and what is, seen as a national standard, so as to avoid
lots of conflicts and fragmentation. So next slide, please. Yeah, so this is just a diagram restating the issue. So let's move to the next slide so that get time. So just to quickly state this, maybe I would explain as we go further. We have a lot of issues in our health system. Either we have too many laws or regulations and across sectors doing the same thing. And then we see overlaps and gaps between state and federal laws. And if there is no effective coordination, we're still going to have a problem. For example, let me give you a practical example in a state that is very close to Abuja, where we have 3 laws on environmental health in the state. We have the Environmental Protection Agency law, we have the environmental law, and then we have the adoption of environmental standards law, all speaking to the same issue. And then we even have a smaller law which deals with a smaller component of environmental health. We have the state waste management law. Now, if these various instruments add the technical support of lawyers, I'm sure we would not have had so many laws around environmental health in one state, which makes it very ineffective, creates unnecessary expenses and resource overload, and general ineffectiveness, especially when you want to enforce those laws. So it's important that as we lawyers, engage with public health authorities, as we'll see in subsequent slides, we should always have a good grasp and a good knowledge of how the health legal system works and the framework works, so that our advice would be very important. So so the next slide. So next slide, please. Yeah. Okay, so this slide just tries to delineate the different legal instruments that are usually, part of the health legal framework. We have the standard legislation, which is often called laws, and then we have regulations, which are subsidiary instruments, and then we have policy documents. So we all are aware that in the hierarchy of laws, legislations are the highest, and they supersede every other legal instrument, save the Constitution. And one of the key issues around public health is the distinction between legislation, regulation, and policy, which most times our non-legal colleagues, tend to mix up the implications of these different instruments. Generally, legislations are enforceable in court and regulations are enforceable in court because they are mandated. But policies are not directly enforceable in court, but they're enforceable within the agency as well as the participating agency if it is a multi-sectoral policy document. And sometimes policy documents can have the implications of a regulation if there is a specific statement in the primary legislation that gives power to make a policy as good as a regulation. Let me give an example where we all know the Bureau of Public Procurement. And in Section 7 of their law, it gives the Bureau powers to, create enforceable policies. And this policy doesn't just cut across, just any issue. It cuts across all aspects of government procurement. And as such, when policies were being considered to develop maybe policy around procurement, policy around procurement of medical equipment, medical devices, or even procurement of food in government institutions, the duty laid with the Bureau of Public Procurement, which was, very, very, very strange to a lot of stakeholders. But because the Bureau is given that mandate, they ought to do so. But they can't do so alone. They have to work with the other participating ministries, agencies, and institutions to ensure that whatever policy they are, issuing out is effective and is enforceable. Next slide. Then there is a distinction that is always important to make between public sector lawyers and private lawyers, because everybody, I think lawyers working in the different sphere have different objectives and motivations. So for public sector lawyers, they basically work within government, the legal departments, and then basically Ministry of Justice, which houses all the lawyers, supporting the various MDAs, both at the federal and at the state level. So they basically support drafting of and vetting of laws, regulations, and policy. And they also are expected to provide advice to government institutions on actions to be taken that have legal implications. And then also ensuring that every legal instrument complies with constitutional and statutory provisions. The only legal instrument is effective and can be enforced. Now, crossing to the other aisle, which is the private lawyers, these are lawyers either engaged by clients who feel that they have been aggrieved in terms of a public health action or measure, or engaged by non-governmental organizations or CSOs to provide legal advice on a development or program intervention. And so they act as consultants. For example, a practical example is on that issue of salt. When you are dealing with issues of regulating salt in the country, you will need to know who to engage. At the federal level, NAFDAC is the authority to regulate salt in packaged and processed food because their law states so. But when it comes to food, presented or sold in establishments, just like restaurants, hotels, that's within the state government and specifically the local government. And this is because of the constitutional provision of the functions of the local government in the schedule. And that, really, really delineates how you engage with government and how the instrument or policy document will be drafted. And then secondly, private lawyers act as advocates, litigate, and like I mentioned, provide technical support. We have had lots of public interest law firms in the past providing litigation support to persons whose rights they have complained has been, either being violated or suppressed, maybe in terms of environmental actions like restriction of movement or forcefully. For example, there was a situation whereby a school in Abuja refused to allow a child because the parent did not provide a vaccination card. And the question was that, is this a requirement under the law? So this situation had to be, judicially determined and explained whether under the Child Rights Act, whether educational institutions can demand that guardians or parents provide such. So lawyers support that. And then we also engage in public interest litigation and advocacy. And the difference, like I mentioned, is that for private lawyers, we look at how we will promote interests of our clients, which sometimes are the public, and to ensure that whatever legal instruments government is considering will take into account consequences for the public and the rest. Next slide. So this slide is, I will just use a few seconds to describe it. As lawyers, we need to work together in the space, whether you're a public sector lawyer or a private sector lawyer, especially when drafting of bills, regulations, and policies are involved. And it's important that at every fora or every time new instruments are introduced, the public sector lawyers should ensure that members of the FBA or professional associations, just like this committee, are part of those conversations. And I think the chairman made mention about his participation in the policy development. And that has been part of the work we have been doing with government to, institutionalize participation of lawyers in critical discussions around health. And, definitely as a public health sector, without, really saying this thing, that sometimes where technical advice or experience of private practitioners might be a little bit higher or more expansive than our colleagues in the public sector. So it's good to always rely, or it can even be vice versa. So it's good to rely on, both level of experience and knowledge in policy or legal legislation development. For areas of conflict, like I said, both have different mandates and different interests. And then there's a financial incentive. So how to align on this is, something that, every situation will, determine best. Next slide, please. So legal instruments in Nigeria, well, there is no hard and fast rule about it, but basically, most often it's conceptualized by government or even by stakeholders, whether government stakeholders or private stakeholders, and then you have to draft the legal text of the instrument, and then stakeholders should be consulted, and a review of the document is there, while the Ministry of Justice most often vet the document and provide legal scrutiny. But here is one of the weaknesses of having just to only vet, because if you are not there at the beginning of conversations or understand some of the nuances, some unsavory provisions might scale through, since maybe you might legal draftsmen are more interested in couching of the words, structure of the document, without necessarily looking at some of the core content and context. Let me give an example of one of the challenges we are facing in this issue. So we have what we call the fat and oil regulation. And in these regulations, we have both the main provisions and then schedules. But the two provisions don't speak to each other. Either there's no connections, provisions to it, and the idea was just, let's just have something. Trans fat is bad, Nigeria should do something about it. But in the main provisions, it was stated every product should have nothing less than 2 grams per 100 grams of trans fat. But when you look at the schedule, the technical components of food products were different. Some were higher, a lot were higher than what the main provision provided. And that means when you're trying to implement the law, which of those provisions would be applicable to manufacturers and food producers? And if we had lawyers who had extensive experience when these regulations were drafted, some of these challenges would have been seen and corrected. Next slide. So yeah, so basically, I think I don't need to say much on our role. I've been already saying it. We need to lead in the drafting and structuring of legal instruments. Over the last 2 decades, that we have been really not present in the room when legal instruments are drafted, and the gaps are very clear. Lawyers are often involved very late in the process, and even the Ministry of Justice, the umbrella agency for legal instruments, participation is really limited to proofreading rather than co-drafting. And this results to missed opportunity to improve the legal quality and enforceability of the regulations. Next slide. So I think basically I wanted to really share how some laws were really passed in the country, and sometimes changes are either required either by our international where we sign up as part of our international obligations, maybe in any conventions or any treaties. Like for example, we have conventions we have signed up to, maybe in the aviation sector. But for the health sector, one of the key conventions was the convention around tobacco control, which I signatory to this convention, and as such, we were expected to domesticate it within a particular time frame. But the process of domesticating still has to align with country context and practices, and also the domestication should ensure that we don't domesticate or we don't enact a law that is contrary or conflict with the spirit of the international convention which we signed up to. So that process will require that both lawyers acting as legal practitioners and even lawyers working with civil society support this process. And that, really, really was very effective. And this led to the passage of the law in 2015. And really working with the Ministry of Health, regulations have been drafted, to operationalize the key provisions of those laws. Next slide. So aside an international convention, there are also issues of obsolete legislations or laws or regulations. So at that point, we need to, as lawyers, push for public health authorities to update and strengthen their laws. And this was very pertinent in animal disease control in the country. We have very, very weak practices around meat inspection, inspections of movement of animals and the rest. And the Animal Disease Control Act was a law that has been in place since 1968 and needed real changes because the rules were different, the practices were different. So when stakeholders thought through it, and we all worked together to push for these changes and to ensure that we had a new and very modern law around animal disease control so as to protect the populace. Next slide. Next slide, please. Hello? Next slide, please. Next slide, please. So we'll just move fast. Next slide, please. Let's move to challenges, please. Yep. Yes. So for the purpose of this presentation, I noted 5 key challenges around lawyers' participation in policy development. One, there is a very, very strong institutional exclusion. Lawyers are rarely involved, and most MDAs, government institutions, do not see it as an important component or important practice. And the roles of the Ministry of Justice at the federal and state level is limited, and it's almost like as if it's a general practice. Most often, lawyers are always brought when there's an issue. Either a provision was drafted that has now been questioned by in court, or having, major policy implications to other stakeholders. Then we have to also look at ourselves. How many legal practitioners have extensive experience or expertise in public health issues? And yet we are faced with public health issues daily. For example, before you leave Nigeria as a person, you are compelled to have a yellow fever card. And the reason for this is because of the various conventions and regulations around yellow fever. And then the Nigerian government passed the Yellow Fever and Infectious Disease Act. And even during COVID, we had situations where every person was told to stay indoors. And even moving between states became problematic at a point. And this begs the question, was that the intention of the international health regulations? And then there are also other issues around treatment, compulsory examination. These are issues that need to be looked into. We have conventions on human rights, and then we have international regulations. So the question is, which is superior? Is it a convention that is treated as a treaty, or a regulation which is a subsidiary international legal instrument? So this knowledge can only be gained if a person is interested and participates in various forums and discussions around health issues. Next slide. So then the other problem is confusions in legal instruments, which I mentioned. Non-lawyers often conflate policies, regulations, and laws. They treat it as almost with the same implications and effects. But we as lawyers, we understand that they are different, and we can only and this also affects the way critical interventions are done. I'll go back to the example of the salt issue. So in 2023, the Federal Ministry of Health issued a food safety policy. And one of the key components was reduction of salt in the country. And to really crystallize that policy statement, you have to be very careful as to what would be the instrument. So a meeting was called, and public health people, we can't blame them, were of the opinion that, since there's a policy document, the next stage should be a strategy roadmap. And I was like, you have a policy document that is already unenforceable. Now you're having a strategic roadmap, which is even worse. I think the best is to pursue a guideline because of the limited powers of the Ministry of Health around salt. And that was how the federal government rethought that idea of a roadmap and went through a guideline, and then mandated NAFDAC to push for a regulation, and then would work with the states to have the states have their own, to domesticate the guideline within their state laws or state legal instruments. So that's a clear example of how we as lawyers can really help our non-legal colleagues in knowing what are the best legal instruments to develop and how these legal instruments can be, enforced or effected. Then also the Ministry of Justice has a huge role to play in the participation of lawyers in public health discourse. And there is need for a clear directive by the Ministry of Justice to really, mandate or make compulsory involvement of lawyers, not just public sector lawyers, but lawyers from the private sector in policy development or legal instruments development. And I think it will really stop the reactive involvement and be more proactive. Next slide. So limited public interest litigation. So we have very few litigations by law firms or lawyers to really test the implication of a law or to really, try to get a judicial interpretation as to how a law would be applied. And we had very few instances. I think of recent there have been some judicial pronouncement as to the powers of VIO. I think for persons who lived in Abuja at some point in the 2000 and 2012, 13, there was an incident of pack and pay, but there was no legal backing for that policy, and the Federal Capital Territory with the municipal had engaged consultants, expended a lot of money to paint roads, to train people to start collection. But it took the intervention of just a single lawyer who felt this is not by a law. That it ought to be an act from the National Assembly should empower the local government or FCT to do so. And that brought the end to that policy and that practice of a campaign in Abuja. But over the years, there has been conversation as to getting it repassed as a federal act and really getting that. But that's the point I'm just trying to point out. And if we do not question some provisions, whether statutory provisions or regulatory provisions or policy provisions, we might be allowing some injustice prevail or pervade in the society. And then there will be limited accountability in the health sector. Next slide, please. So it's not just to speak about the problem 24/7. What should we do to get things right? One, we need to include lawyers mandatorily. So it's not more of a pacifist behavior or tokenism, but lawyers should be mandatorily included in deliberations or conceptions of legal instruments at the public level. And as what the MBA committee is doing, we need to start building expertise around public health, especially on the part of sanctions to the general public. Public health measures are very, very critical issues. I don't know. It has always been a very big issue. There are some regulations. I think there were some regulations around disposal of persons, and the populace were not involved. And enforcing that regulation or guideline was very problematic because every person, like if you had a colleague or a family member who passed on from COVID, you would want to pay your final respect. But if a guideline provides that such body should be cremated, that goes against your either religious or traditional beliefs. So how do you merge it? So the first guideline had requested for cremation, which was the internationally recommended practice. But after difficulty in getting that, it had to be amended to reflect societal expectation. So we now had a burial conducted by the appropriate health authorities to ensure that the body is properly buried and there are no risk to the public. Because I will give an example. There is a very, very virulent disease called Lassa fever. And a person who dies of Lassa fever, even dead, is a risk to the community. So you don't get to bury the person just anyhow. It has to, you have to really protect the public. You have to ensure that the person is not buried close to a water source. Otherwise, the fluid from the body can enter the water source and definitely cause a major problem. So all those are very important. Then we need to also start helping to develop model instruments to guide our public health institutions. In a lot of crimes, private lawyers, think through problems for government and provide guidance to government. And I think, that should be one of the, outcome of specialized bodies, public health bodies, and also the MBA, if there are resources to do so. Next slide. Hello, next slide. All right. The last two suggestion has to do with litigation, which is one of our core hobbies. We should, try to see if we can support public health interest engagement, either to litigate on issues or to try to, work with the judiciary to, ensure that implementation or enforcement of public health laws are not draconic and are not excessive. For example, we have seen situations whereby in environmental issues where someone maybe comes out and the person is, apprehended, the fines that are being ascribed or made to be paid are in a very, very high, sometimes 50,000, 60,000. And for those sort of offenses, which are, like, simple offenses, that's quite a very high amount, and lawyers should start working with our judicial officers to ensure that a lower limit of punishment is considered rather than the ceiling, unless the provisions of the law states otherwise. Then for collaboration is to encourage development of collaborative models between the public health lawyers and the private health lawyers to work together once there are issues around public health. It really helps to get the private lawyers engaged in the process and also contribute very effective, because the private lawyers are the ones that will really react on behalf of the general public as to the provisions of health laws, regulations, or policies. So, yep. So, next slide, which is like a call to action. So, we must, as lawyers, claim our proactive roles in health governance and instruments development. So, private lawyers, I would always suggest it's not everybody that can be, a public health expert, because it's a different ball game from what is in usual corporate books. But it's good to understand how public health law works so that you can react accordingly if a situation arises. And it's to also, try to we build a community where information and resources are shared regularly to build the knowledge and capacity of lawyers who are interested in public health initiatives or issues. So, yeah, I would say this is my conclusion, and I thank everyone for listening. And I will take questions.
Okay. Oh, thank you very much, sir. Thank you for sharing with us your wealth of experience. Indeed, you've spoken to us as an expert, and I believe we are well nourished by this, by your presentation. Yes, sir. So I think on the question, we have like two questions here. So I'll be reading them out. We have one from Professor Rotimi Jayesimi. Is asking now the question that I read. The Abuja Accord recommends that the African countries should allocate 15% of its budget to health. Nigeria has only achieved 4 to 6%. What legal instrument can be utilized to make it mandatory for the government to actualize this? This is from Professor Rotimi Jayesimi, a UK-based medical doctor, visiting professor of the Faculty of Law, University of Ibadan, and an adjunct professor of Faculty of Health Law and Humanities, University of Medical Science, Ondo State.
Yeah, thank you. It's so clear, but it's so difficult. It's so clear and it's so difficult. One of the ways of doing so is by passing a national legislation on it. If we are all, I don't know if everyone is aware that there is a law called the National Health Act, and in the law it provided that 2% of the country's consolidated revenue fund should be used for specific issues, and there are like 4 gateways. We have the issues around health insurance, issues around improving primary healthcare centers, issues around emergency treatment and issues around, blood transfer and the rest, and then maybe ambulance services. Now, only a legislation can compel the Ministry of Finance and even the National Assembly when they are pushing for the Annual Appropriation Act to, ensure that this 15% is mandated. But that would take a lot of political capital because, the question is always like, okay, if we are giving health 15%, what will we give education? What will we give housing? What will we give other sectors that are also crying for these limited resources and funds? So the answer is very clear. The National Assembly can solve that problem once and for all, but the political will and capital to get that done is presently not there. I can speak from experience on that. Yeah.
Okay,
thank you very
much, sir. Yes, there's another question. This is a question from Mr. Ignatius Agbapulu. His question reads, is it true? Well, I don't know. Well, I think any other person that has knowledge on this can answer this, but let me put it up to our guest. He said, he's asking, is it true that coronavirus injections taken by some people last year is now having serious negative effects on those who received the injections in Nigeria in particular? That's the question, sir.
All right, thank you very much. And it's also very critical issues around how our public health system works and how we mirror it with other countries. As a country, we work closely with WHO. WHO provides guidance, especially when there are public health emergency of international concern, and provide recommendations. So as a country, we try to align with every other country. However, in some countries, there are laws around vaccine injury, particularly the US. And then again, these laws sometimes try to provide protections to manufacturers, especially when government accelerates vaccine development. A lot of times, vaccine development takes between 5 to 7 years because you have to go through testing, clinical trials, confirmation, regulatory approval. But during COVID, there was an express approval and waiver of the process to kickstart, to ensure that a vaccine was provided to resolve the issue. So that is within the laws of those countries. The Human Health Act of US gives the president, through the Human Health Services Secretary, to do so. But do we have such laws or provisions in Nigeria where government can either one, expressly allow for vaccine use in the country, and then two, when there is an issue or a vaccine injury, who bears the burden?
Yeah. Okay, thank you very much, sir.
Where there's a limit, and if you can actually show that your injury, like in thought, it is there's a nexus between what you are suffering and the vaccine you took, then you're entitled to compensation. But in a country like Nigeria, we don't have that, and we're exposed to whatever situation, and the only grounds we have is the normal grounds around negligence, and as we professionals to help, look at provide guidance in the suit or the litigation. Let me also give an example. I don't know if we have all heard of one incident that happened. One Peking powder, I've forgotten the name. It happened in Kano, and it resulted to death of lots of children. And the most funny part of it was that it was a pathology in ABU that discovered that what caused the death of a lot of children, especially in that vicinity, was the problem with that teething powder. The teething powder was called My Pikin. And this is a product that has the NAFDAC registration number, but what happened during production was that the officer who was asked to go and purchase the elements was a very new person, just out of the university, did not read the label well, purchased the wrong label, a cooling agent, and this was included in part of formulating the baby powder, which led to a lot of death. Now, NAFDAC has the resources. It sued the manufacturing plant, which is Barewa, closed it down, got some of their officials criminally indicted and imprisoned. But nobody ever sued on behalf of those parents, families who lost their children over that incident. And we all know in law that judgment given can be used to, as truth. But if we don't have people following up with families, and in Nigeria we have a lifestyle of, and I still got one term, sorry if I'm using that term. So we have not seen people being really, really made liable for injuries caused by either medical products or health products. Over.
Okay, thank you, sir. So we have other questions from the YouTube channel. I think Damilola, please, can you read them out for us, please? Thank you.
Okay. We have participants on YouTube, and we have some questions there. So I'm just going to scroll through to see how much I can see for now. Okay. So this is by way of a comment from Amuchi Okparago. It is very important that public health lawyers and private health lawyers collaborate in public health issues. That's more of a comment. But there's a question here from Gospower. How can enforcement mechanisms of public health laws in Nigeria be strengthened? We have so many laws on public health that are lying dormant without enforcement. That's the question.
One of the reasons why you have changes in public health is because when an issue affects a certain class of persons, reform is triggered. So the reason I'll give you an example. This is almost 7 years of trying to have a public health emergency national legislation. And the present 10th Assembly is not really keen too much on it because they didn't experience it. They were not in the class of the 9th Assembly, the 2020 set, who were either stopped from traveling or asked to compulsorily be isolated or quarantined when they did return from various trips. And some of them actually suffered the coronavirus and had to undergo extensive treatment. We also had situations whereby top persons were unfortunately taken by this virus. And this triggered the need for reform at the National Assembly. But unfortunately, the reform process took too long and there were too many conflicting interests on how the law should work. So at the end, we didn't have a law. With the 10th Assembly, well, they don't see it as an important aspect of reform. What they see as an important aspect of reform is what would make you come back as a legislator, which is establishment of a federal medical center in your senatorial district. So if you look at the bills or legal instruments in the National Assembly on health issues, they are more of establishment of federal medical centers because this is a political advantageous bill than a bill that will solve problems that you can't put monetary value or campaign value to. So yeah, so that's it. And then again, there's really limited pressure from the general public on reforms. I think it's only a few sections of the society that pushes for reform. But once there's a coordinated and general push for reform, more often government will react and try to see what they can do to, calm the nerves of the general public. Over.
Okay, so that's the only question I can see on YouTube.
Okay, so we have another question here from Professor Rotimi Jayesimi. He's asking, he said that can't a class action be brought against the vaccine manufacturers as was the case against Pfizer when children were enrolled in a study and resulted in the death of children? So he's asking whether they can't they institute the class action. Just I think it should be related to the scenario you gave us about the powder that killed some children in Kano State or so. I think that.
Okay, so basically, I might be a little bit rusty on litigation, so forgive me. But class action in Nigeria is not that expansive or very, very promoted in terms of making it easy for litigants. It should be a good option because litigants might not have lots of resources, so it is good to band together to pursue it as a single goal. Then secondly, if you're considering class actions in Nigeria, you should also look at every individual person who was affected by that vaccine or that health product has to prove their case. We don't have provisions in our law that minimizes some issues around health negligence or medical negligence. We still have the normal duty to a litigant that you must prove your case. So having 20 litigants is that all 20 litigants must show that they were affected and that there's a direct nexus to it, and then they suffered injury, if I'm not wrong, because it's clearly negligent. But if you have a law on, let's say, health liability, which limits some of the provisions of the Evidence Act, which also remove barriers that are in our various procedures, whether high court procedures and the rest, then we can see class action as a very good tool to get people to be accountable and liable for their negligent or actions or thereabout. Yeah. But at the moment, every man for himself in terms of how the law works on this issue.
All right. Okay. Thank you very much, Mr. Ememudo. Thank you for your time and the industry put into this, and thank you for your life.
I think we have one more question on YouTube. Apologies, Selzin.
Okay.
Can I take that?
Yes, please.
Okay. So someone is asking, thanks for this insightful seminar. That's Penina. Please, my question is, what is the position of the law when a patient withdraws consent after making part payment for the procedure and wants a full refund? And for context, the medical facility has already incurred some expenses in anticipation of the surgery, and the patient suddenly withdraws consent and does not want to go ahead anymore. And note, this is an elective surgery.
Well, the answer of this question is neither here or there. It will be determined by the preponderance of evidence and by competent court. But what I'll say is that a patient and the hospital are bound by whatever agreement or arrangement they have done. So if there is no, what will I say, any agreement between the hospital that provides for the patient losing his funds when he elects not to proceed, then, well, you can get your reimbursement because contracts are regulated by the laws of contract in Nigeria and the various judicial principles that guide either frustration of contract or termination of contract and the like. So it's a duty for the patient to understand what are the terms and conditions that were provided when he or she signed up for the surgery, and what avenue do they have to get refund. But if there is no protection to the health facility, then you can collect. But if not, I think there are rules around quantum merit, which the hospital can also claim in their own aspect. Yeah. So that's my take, but I might be, not too correct if a judge rules otherwise.
Okay. Thank you very much.
Okay. Sorry,
Okay.
Selzin again. There's I saw one more question on YouTube.
Okay. Okay.
Okay. So someone is asking, what is the effect of oh sorry, I saw that question again. Okay. What is the effect of Section 14 of the National Health Act on health operators in Nigeria? That's by Gregory Tochukwu Okere.
You know, since 2014, when the National Health Act was passed, there are lots of provisions in the law that is not really tested, which calls into question some constitutional issues. I know I've been a promoter and I've worked with the Ministry of Health and also key committees. For example, the National Council on Health. Can a federal law create a National Council on Health when the issue of health is not an exclusive or concurrent issue? Those questions have not been asked. So when we look at the provisions around health facilities generally are within the purview of the state where they are registered to operate. And then their personnel are then required to fulfill the professional requirements provided by federal law, because federal law provides for many of the professional requirements in the health facilities, from doctors, nurses, dentists, midwives, and the rest. So having a national law trying to regulate state institutions is difficult. It's difficult, as we have seen in the Child's Rights Act, whereby after the Child's Rights Act was passed, the euphoria was there, but by the time Ministry of Education, Ministry of Women Affairs tried to, work with the states to enforce it, they found out that issues around children welfare and their rights is not a federal issue. And then a new campaign started to ensure that all states have their own child right law. And in Nigeria, child right law of states are not even the same. Different states with different definitions, different expectation, and that's how it is. So that's a position that has not yet been judicially determined, to my knowledge, and as such, health facilities are still complying with instructions from the Ministry of Health, because there is this, basically deference to the Ministry of Health when it comes to, coordination, when it comes to enforcement of issues. But when push comes to shove, we might, see a difference in how things are done. Yeah. So that's my response to that. So it depends on how it is. But one other issue I've always, tried to think through is, if those provisions create criminal liability, I think then the health institutions would comply, because the police is the federal law enforcement agency and are expected to enforce laws by the National Assembly. But if it's about some issues, but like I said, how should I say, it's still conceptual, or it's just like, this is the thinking and this is what I've written about in the past. So yeah, so that's the issue around enforcing federal legislation on health. Over.
Okay, thank you very much. Dami, do we have more questions from YouTube?
From the chat? So far, we don't have any more questions, but if you're ready to close, I will take the opening remark on behalf of the chairman of the committee. So if you're ready to close, you can just let me know.
Okay. Before we do that, Professor Rotimi Jaisine has shared some knowledge with us, some insight, and let me read that out. I think it has to do with the Pfizer vaccine that we talked about. Yeah, he said the drug company Pfizer has paid out $175,000 to each of 4 families whose children died during a study of an experimental antibiotic in Kano, Nigeria. But the settlement has been strongly criticized by the families involved and by a leading ethicist in the United States, where Pfizer has its headquarters. The study was conducted during a deadly outbreak of meningitis in 1996, when some 200 children were enrolled in the study. half were given Pfizer's experimental antibiotics, Trovaxoxacin. Please pardon me if I didn't pronounce it correctly, which it markets as Trovan, and half were given Syntrax. Oh, I'm a lawyer, I'm not a medical expert, please. 5 children died in the Trovaxoxacin arm and 6 in the Systraxone arm also. Yeah, so this comment, it's in the comment, it's in the chat box there. So thank you very much, Professor.
Well, I just saw one comment, one question by Chinwike Ezebube. He's like, what extent does international influence happen to apply to our local health laws? Well, the influence is based on if Nigeria has signed up on an international legal instrument. For example, Nigeria is about to indicate its support for the pandemic treaty or the pandemic agreement. And once we indicate that, there is an obligation by the National Assembly to domesticate it. But the international health regulations, it's also a binding legal instrument, and then we also signified our intention to be bound by it. And definitely, we have a duty to domesticate it in our local laws. And domestication involves both national and at the state level. However, there are some international guidelines, international prescriptions on issues. Those ones do not have heavy influence in Nigeria, but can be used to guide development of instruments or improve practices in the various fields of public health. Over.
Okay, thank you very much. Thank you very much. Dami, before we take your closing remark, let me also remind those participants that are on the call that are yet to fill up the attendance for the CPD points. Please do that, because we'll be rounding up the call in the next 1 to 2 minutes. And once that call ends, the form will be closed for that. So please kindly do that. Kindly fill up the form. Thank you. Okay, Dami, please.
Good afternoon, distinguished participants. Thank you for staying on the call this long with us. Thank you for joining us on another series of the Health and Medical Law webinar series of the MBA Garki branch. So a few announcements on behalf. Apologies, the committee chairman had a bit of technical glitch, so he's unable to connect back to the call. A few announcements. We do this every month. So for next month, the topic we'll be considering next month is understanding patients' rights and legal remedies in Nigeria. So make it a date with us to join us. The announcement, the date, and all the other information regarding to that session will be published at some point. So please stay tuned, keep your eyes open. We generally advertise across the different MBA WhatsApp groups. That's number one. Then the CPD link has been shared severally. So please, the link will only be active for the duration of this webinar. So kindly fill the form, please. So what I'm going to do is I'm going to give an additional 5 minutes. So we're going to keep the meeting room open till 3:30, and I'm going to keep resharing the link. So please keep your eyes open. Look at the chat box if you're on Zoom. On YouTube, keep checking the comment section. If you're experiencing, we have had people who have been able to fill the form. So if you're experiencing any challenge, it could be your internet that is hindering you from filling the form. So please keep checking again and again. But for the next 5 minutes, we're going to keep the meeting room open. If you fill the link, you can exit the meeting. Thank you very much. We'll see you next month. But if you're yet to fill it, the link will be reposted severally for the next now 4 minutes. So just keep your attention on the chat box or the comment section, you'll see it. And thank you once again for joining us. On behalf of the Medical and Health Law Committee, enjoy the rest of your day, and we hope to see you next month. Thank you. Selzing.
Yes. Okay. All right. Thank you very much, Damilola, and thank you to all participants for joining us. Special thanks to our guest speaker, and I hope to have you all on the call next month. Thank you and bye.